Good evening and welcome to CASA's webinar on the proposed new rules for smaller aeroplane air transport operations. I'm Jason McHeyzer, the Manager of Regulation Implementation Branch at CASA, and with me is Scott Watson, the Manager of Flight Standards Branch. For the next hour or so, we'll take you through a brief summary of the proposed changes under Parts 119 and 135 of the Civil Aviation Safety Regulations. Then we'll attempt to answer your questions. And we'd like you to actually start asking your questions now if you like. At the bottom right hand of your screen there's a little ask question tool, and that will mean that we've got questions ready to go at the end of the presentation. So we're talking about the proposed new rules for small aeroplane air transport and the related AOC requirements. Right now the consultation for these rules is open on CASA's Consultation hub, and you can see the address on the screen there. The consultation closes on the 2nd of September. The Consultation hub provides a list of the main changes and where to find them within the rules and manuals of standard. It also has a document that summarises the proposed changes, as well as our draft guidance material, and of course the draft Part 119 regulation and Part 135 regulation and manual of standards. There's no manual of standards for the Part 119 regulation. So how does this fit together? At the moment, CASA is developing 6 flight operational regulations that are all very tightly related. Part 91 is the general operating and flight rules. You can think of these as the rules of the road. So these are rules that apply to everyone unless they're specifically turned off or modified by one of the other parts. Then, as you can see, Part 119 is the air transport operations rules. So these deal with certification requirements and things that are in common for all air transport operations. Underneath that, you can see the 3 parts dealing with the specific operating rules for larger aeroplanes, smaller aeroplanes and rotorcraft. And we also have a different set of rules under Part 138 for aerial work. Scott will now go through a bit more detail on both 119 and 135.
Cheers, thanks Jason. Good evening everyone. So I just wanted to briefly start by describing how we got to where we're at the moment. Obviously, this is a project that's had a very, very long genesis, and it's been through a number of iterations over the years. We started in 1998 and there's been through multiple consultation phases over that time. Looking more recently, in 2013, there was a particular notice of proposed rulemaking that discussed generically moving the aerial work ambulance function into the air transport space. In 2018, this year, we've been updating the regulations. In June, we had an industry working group that reviewed the draft 119 regulations, the 135 regulations, and the draft 135 manual of standards. And that working group was appointed by CASA's new advisory body, the Aviation Safety Advisory Panel. In July, following the working group produced a list of approximately 35 issues across Parts 119 and 135. During July, CASA worked on updating the rules to reflect our responses to those issues. In August, we published the issues list. It's available on our website under the Aviation Safety Advisory Panel part of the website. And that issues list also includes CASA's initial responses to those particular matters. And obviously in August, we commenced the public consultation, and as Jason earlier mentioned, it concludes on the 2nd of September. So why are we changing the rules? As always, our number one driver is safety. Underlying data from the ATSB over the last decade and a half shows that there is a significant disparity in the accident rate between charter and low capacity RPT. CASA is seeking not to eliminate this disparity, but reduce this disparity. So the leading accident category, amongst others, was collision with terrain, and a common contributor to all the accidents was ineffective or inadequate monitoring and checking. Cheers. Other reasons why we're looking to change the rules is that an activity-based regulatory model enables better safety risk targeting. So by moving to the CASA part system, we're moving away from a system of regulations that embeds air transport rules, or charter and RPT as they're currently called, with aerial work, with flying training, with private flying, and all the rules are jumbled in together. It makes it very hard to decide from a safety perspective which rules should be adjusted in one way or the other. So by moving to a CASAR part system, it really enables us to target the safety risks of particular activities. So as Jason previously explained, we've essentially got 4 CASAR parts that are covering air transport. That enables us, and by dividing up, if you will, those air transport activities into the 3 operational air transport parts, 121, 133 and 135, we can target the safety risks applicable to different parts of the air transport space. Part 138 allows us to target safety risks or appropriately ameliorate safety risks for aerial work activities, and similar across the other parts, for example, 141, 142, 137, etc. One of the other things with changing the charter and RPT into a common model of air transport is that it removes regulatory barriers to air transport competition. In essence, at this point in time, charter operators will now be able to advertise to the general public for scheduled flights, which they weren't previously allowed to do. So for rural and regional areas, for example, where there aren't a lot of RPT flights currently, charter operators will be able to advertise generally through the papers, internet, TV, etc., for scheduled flights in those areas if they wish to do so. Another reason is that we're going to consolidate numerous regulations, as I said, that are somewhat all jumbled together, CAOs and multiple other legislative instruments and exemptions, into a singular suite, if you will, of rules, where if you're doing a particular type of activity, it should be easy to know which part of the rules applies to you. The rule changing, we are also changing the rules to align where appropriate with international best practice and where it's practicable to enable higher levels of international civil aviation organisation compliance, which is a requirement of Australia as a signatory to the Chicago Convention to do that. Cheers, thank you. Part 119 then. So what are the major things that are happening in Part 119? We're turning charter and RPT into a common phrase, air transport. And air transport has 3 major subsets: passenger transport, cargo transport and medical transport. And there's particular definitions in the definitions document available as part of the consultation documents so you can understand what those are. But what's important to understand is that in the operational rules, so in Part 135, as we're talking about tonight, there are particular segments of the rules that apply to each of those subsets. So, for example, if you're doing a cargo transport operation, there's a number of rules that don't apply to you. So Part 119 has a number of common rules for all air transport operators, and they're all scalable for size and complexity. So, for example, there is now a requirement for crew training and checking for all air transport operators. So that's going to be a new thing for many charter operators in the less than 5,700 kilo space, to whom CAR 217 doesn't currently apply. Training and checking in 119 has some generic requirements that apply to all training and checking organisations. And in 135, there's some specific training and checking requirements about exactly how you train your crews. Other things in 119 are there's a common requirement for human factors training. There's a common requirement for a scalable SMS, and that is built into the regulations, and we've provided an amount of initial draft guidance in relation to the scalability of an SMS. There's also a requirement for a safety manager, but we've been quite specific in the draft guidance that a safety manager does not have to be a full-time person. It can be a part-time person, it could be a contractor. There's a number of different options that could apply there, and we've copied that idea shamelessly from other regulators and matches international best practice. There's also requirements in 119 for your exposition. There are a number of requirements in there in 119 where it states what type of information must be in your exposition. There's also a number of additional requirements in 135 about specific matters that apply to that type of air transport operation. The most important thing to understand about expositions is that CASA isn't mandating what the exposition must look like. It could be a singular document with a number of different parts. It could be a number of separate documents. All that we ask for an exposition is that you identify what the pieces of your exposition are when you provide those documents to us. Cheers. So Part 135, I'm not going to touch on all of these right now, but these are some of the notable changes. There's a requirement for a minimum equipment list where there is a master minimum equipment list from the manufacturer for international operations and for IFR domestic operations. There's requirements for the suitability of an aerodrome to be defined by the operator with a list of criteria that the operator needs to establish. The simulator rules are now based on MOPSC, which is a term that underpins the delineation between parts 121 and 135. It stands for maximum operational passenger seating capacity. So it's the maximum seating capacity that you've decided to have on board your aeroplane. That can be, if you choose to do so, it can be different to the certificated seating capacity that comes from the manufacturer. We've aligned the oxygen requirements for non-pressurised aeroplanes with ICAO, and that's resulted in some relief compared to our current rules. There's a requirement now, under certain circumstances, to have a takeoff alternate. We've also got single engine requirements for IMC or night operations, where if you're going to conduct those, then in a single engine aircraft for air transport, then you need to have what in the new rules is called a prescribed single engine aeroplane, which matches up to what is currently termed an acceptor aircraft. We've changed slightly the requirements for single engine requirements over water. We have a new requirement for night VFR operations require a flight crew member to be IFR qualified in accordance with Part 61. We have a requirement for night VFR and IFR operations for aircraft greater than 5,700 kilos only, for only passenger transport and medical transport, to have particular types of terrain awareness and warning systems fitted. And there's some slightly modified weather radar requirements, but they're very much largely identical to the current requirements for that. So consultation feedback. In relation to obviously your general comment, in addition to your general comment around how the rules are going to affect you and your views on the rules, CASA also has some specific matters that we would like to request your feedback on. In particular, which requirements will require longer than March 2021 to implement. So we'll talk later about this, but the rules, CASA is proposing to commence the rules in March 2021, so approximately 2.5 years from now. So we're looking to find out from industry what particular requirements of the new rules are difficult to comply with in that 2.5 year period, and that you need more time for it to comply with. We're certainly open to those suggestions. We're also interested in your views about the rules surrounding single-engine aircraft over water and over land. Are they appropriate? Have we hit the right mark? We're interested in your feedback on that. In relation to simulator training, you will notice that we haven't mandated any simulator training at the current moment in time for Part 135 aircraft. We're interested in your views on whether we should or whether we should keep it as we currently have it, whereby we haven't mandated any at this point in time. So what are the timelines for the regulations? CASA is currently aiming to make the regulations by the end of 2018. Following that, we're aiming to have the guidance material that's essential for you to understand the rules available for industry by early 2020, and we're aiming to commence the regulations in early 2021. Unlike recent regulatory implementations such as Part 141 and 142, CASA isn't proposing to have any transition period apply to these regulations. So on a date in March 2021, the most likely date we would pick would be one that's aligned with an AIP amendment cycle. On that particular date, the identified old provisions of the CAR 1988 series will no longer apply, and the new CASAR provisions will apply. So there'll be, if you will, a single date cutover. And that's why we're interested in what provisions are going to be difficult to comply with by that point. The possibility exists, based on your feedback, that we may have certain provisions of Part 119 and Part 135 for certain parts of industry apply from March 2022, March 2023, etc. As an example of that, in the draft regulations, CASA has already stated in the or drafted into the regulations that the TORS requirements, for example, don't apply until 2 years after the commencement date. So if the commencement is in March 2021, then TORS already will not apply until March 2023 for those applicable aircraft. Our plan in relation to permissions such as AOCs is that there's going to be a series of deeming provisions. So CASA has no intention to reissue everyone's AOC prior, on the particular date in March 2021. Our plan is to make the maximum use possible of deeming provisions, such that, for example, if there's a requirement in Part 119, as there is for a training and check for an operator to have a training and checking system, if you already have a training and checking system under CAR 217, it is likely that that system will be deemed to be equivalent to the Part 119 system until the next time that your AOC comes up for renewal. CASA will also be looking for operators to conduct gap analysis and develop a transition statement to submit to CASA. And I'll just hand over back to Jason to have a chat about a couple more areas. Cheers.
Yeah, thanks, Scott. Look, one of the questions that we've had during the technical working groups that we've had with industry and really throughout the reg reform program is the question of strict liability. And look, we know this is not particularly popular. However, I think a lot of the unpopularity is maybe misunderstanding what strict liability is all about. So unfortunately, it's hard to talk about strict liability without getting a little bit into legal terminology. But strict liability relates to the fault elements of the Criminal Code Act of 1995. So prior to 1995, strict liability wasn't explicitly written into regulations. But if you have a look at existing CASARs and the old CARs, the Civil Aviation Regulations, you'll see strict liability is explicitly called out. But it was implied in earlier regulations. Strict liability is only used in limited circumstances. So when you're trying to protect public health, safety or welfare, deter some form of conduct, and basically where the need to prove someone's mental state, what were they thinking when they committed an act, would militate against the object of the law. So where you don't want to have to prove that mental state in order to be able to prove the offence. That's the key part of what we're trying to do with strict liability. And generally the penalties are less severe in strict liability offences. So we've got a strict liability clause, and we've got a number of them in the CASAR parts, including 119 and 135. Does that mean that you're guilty automatically? Well, it doesn't. You're still innocent until proven guilty. There's a burden of proof on the prosecution that the physical act occurred. So if the rule is that you weren't allowed to fly below a certain height, it still has to be proven that you flew below that height beyond reasonable doubt. So there's quite a high burden of proof for the physical act. But there's no requirement to prove the mental state or the fault elements of the act. So we don't have to prove that you intended to do it or that you knew that you were doing it or that you're reckless or negligent is not required. So we still have a fairly high evidentiary burden. And even with that evidence, there are defences available. The first one under the criminal code is a mistake of fact. So you thought something was true, but it wasn't. You had an altimeter that told you that you were flying above the height. It was reasonable for you to think that the altimeter was correct, and so you acted on that on the facts available to you. That is a defence. Similarly, within the Civil Aviation Act, there's explicit requirements that talk about the ability to effectively break the rules because of weather and other complicating factors. And in the Criminal Code, sudden or extraordinary emergency permits you to do things that would otherwise not be permitted. So there's a lot of defences available should you be tried for a strict liability offence. However, before you even get to court, CASA still has to apply just culture, and nothing in strict liability stops us using discretion, same as a police officer might use discretion when they've pulled someone over for an offence on the side of the road. So CASA's current just culture provisions and discretion mean that we do very little prosecution, but we have a role to do so if that's required in the circumstance. So hopefully that's helped untangle some of the mess of strict liability. It's not something to be feared, but it is something that is commonly misunderstood. So what do we do from here? As we've said, the consultation is currently open on CASA's Consultation hub. So once the consultation finishes, all the submissions will be registered and reviewed by CASA officers. Where you have given us permission to do so, we will publish your submission so that everyone can see what's been said. And in our experience, the majority of people give us permission to do so. CASA will evaluate the comments that are provided and will make changes to the regulations where we see that as appropriate. We also will have the Aviation Safety Advisory Panel and their technical working group. We'll give them an opportunity to have a look at our intended response to each of the pieces of feedback and provide advice to CASA on what they think we should do. So even after consultation, there's significant industry engagement. Following that review by the Aviation Safety Advisory Panel, we'll publish our summary of consultation, and that will tell you not just what was said, but what we intend to do about it. And then we'll incorporate those changes prior to making the regulation. In terms of transition, and Scott's covered part of this, we'll make the regulation, and we're aiming to do that by the end of this year. However, we've given some guidance material with consultation, but there's a lot more guidance material that we intend to develop. We also intend to develop sample manuals that are applicable to smaller operators. We've got some pretty significant positive feedback on the sample manuals that we produced for Part 141 and the sample exposition for Part 142 operators, and we intend to basically take those, do the same thing for smaller air transport operators. We also intend, in addition to the sample manuals, to provide some acceptable means of compliance for other areas, or there might be multiple acceptable means of compliance to make it easier for you to select something that we're pretty much going to automatically approve. We'll provide templates for gap analysis to look at the common pathways from the current rules to the new rules. Classic example being you're a small aeroplane charter operator at the moment, and then you're going to move into CASA Part 135 with the additional requirements to comply with Part 119. We'll identify what are those differences so that you can then use that to develop a transition statement telling us how and when you intend to change your manuals and your operating mode to fit the new rules. And what we're planning is to make the rules this year, and we intend to have all the support available by early 2020. So around the March 2020 time frame, we want CASA to be completely ready to help industry to transition to the new rules, and then you'll need to comply with the new rules in early 2021. And as Scott mentioned, subject to your feedback, we expect that there will be some delayed provisions where you've got longer than early 2021 to comply with those delayed provisions. So, time to go to questions. As I said, there's a little box in the bottom right hand of your screen that says "Ask a question." I know we've had a few questions before the webinar, so we'll kick off. So, Scott, how is Part 119 going to affect smaller operators?
Yeah, so obviously for smaller operators, some of the requirements are going to be new. I think I've mentioned some of them already, training and checking, human factors training, for example, safety management systems. So there is definitely going to be an effect there, but really what CASA is really emphasising is that a training and checking system for a smaller operator, just to take that as an example, or a safety management system for a smaller operator, we do not expect a safety management system for a smaller operator to be the same as Qantas's safety management system, for example. So there will be the same generic headline requirements, but the implementation of that and the level of detail and the way, for example, that a smaller operator implements their SMS will be vastly different, than what it would be for a major airline. So the SMS training and checking systems, they are all scalable to the operator.
Okay. Look, I guess it's a related question. Will the new Part 119-135 require all Part 135 operators to have an approved SMS in place? Yeah,
so all Part 135 operators will require to have an SMS. Again, one of the things that we're very interested in your feedback for the regulations is, for example, your take on is March 2021 going to be a suitable time frame for an SMS, or should we provide a longer time frame for operators to whom an SMS is not currently required so that you've got more time to comply. Certainly CASA is well aware that there's an education piece that needs to be done in relation to SMS. One of the reasons why we're having such a long period between where we're consulting and when we're planning on commencing the rules is because we fully recognise that there is a significant education piece that needs to be done with both our own staff and with the industry in relation to a number of matters, and we've deliberately given ourselves a substantial amount of time to accomplish that.
Yeah, and if we look at how we implemented SMS for high-capacity RPT, for example, we had an implementation plan, so we weren't expecting a fully functioning SMS on day one.
Yeah, and that's a really good point because safety management systems, by their very nature, they require it to be developed over time. So it's essentially almost an impossibility that your safety management system can be fully functioning on day one. So it is very much a case, that CASA will be looking to, work with industry and work with operators, to have implementation plans and to help you to put those in place and to identify what the steps are that you need to carry out.
Okay. The next question is, when will CASA listen to what industry needs as opposed to continue to tell industry what CASA thinks we need? I'm happy to start this one.
Sure.
Look, effectively what we're trying to do here is exactly what the question is asking us to do. By having a consultation that's open to the public, we're certainly aiming to take feedback from the public and use that feedback to help us shape the rules. And this webinar is part of starting that conversation with industry on the consultation that's underway at the moment. But as Scott highlighted earlier, this isn't the start of industry involvement in this process. It's been going for a long time, and we changed the consultation drafts at the moment based on industry feedback from the technical working groups. And those technical working groups were basically composed of industry professionals who are operating in what will be the 135 space, so broadly small aeroplane, charter and RPT operators. So a room full of small operators and a couple of CASA staff going through the rules in detail, providing feedback, and that's really resulted in some of the changes that are already in the rules today.
Yeah, definitely. The other thing I'd probably like to emphasise about the technical working group is that it's probably not well understood, but CASA did not choose the people that were on that working group. So the Aviation Safety Advisory Panel, they were the ones that chose who was on that working group. So that CASA was not involved in any way, shape or form in selecting those individuals.
Yep. So we've done consultation to get here. Consultation's open at the moment, and even after consultation closes, we'll go back to the technical working group and Aviation Safety Advisory Panel to confirm that what we're doing is the right thing. Although, at the end of the day, we may have a role as a regulator to prioritise safety over cost, but only where there's a really clear, justifiable case to do so. Yep. So there's a question here about how will Part 135 relate to Part 138 for operators who conduct work across both charter and air work at the moment.
Yeah, so obviously this comes back to the activity-based model that I talked about earlier on. So Part 135, being an air transport operation, has a requirement for the issuance of an AOC. Part 138, which we're aiming to discuss further with industry later this year, is no longer will have an AOC. So Part 138 is somewhat similar to Part 141 in that there will be a specific Part 138 certificate that will be issued for those operators. So one of the things that we'd like to emphasise in this is that although we're going to an activity-based model, we don't expect operators to produce two sets of manuals. Again, in large part, if, for example, you're complying with all the Part 119 and the Part 135 requirements to get an air transport AOC, it's highly likely that there'll be very minimal additional effort in order to comply with the Part 138 requirements. So again, that's part of the guidance material that CASA is planning on developing, is identifying what are the differences between the different parts. We're very cognisant of the fact that operators conduct activities or conduct multiple different activities. There are many operators, for example, that do both Part 133 rotorcraft air transport, also Part 135 smaller aeroplane air transport, and also Part 138 aerial work activities. So we'll be producing guidance material that tells you the differences between those parts and how you can comply with them in a coordinated fashion. Certainly our aim is that, in general, if you let's say you're a new operator in April 2021 and you want to do activities in both Part 135 and 138. You fill in a single application form, you tick off the activities that you wish to conduct, you submit a single set of manuals to CASA that cover off on the requirements of both parts, and then you may get handed multiple pieces of paper at the end of the day, an AOC and a certificate, but it's one application process to get to those two pieces of paper.
And obviously, you know, when you're conducting aerial work operations, there might be some slight differences in the rules that apply during that operation. Yep. You know, minimum heights, you know, different things that you're allowed to do within aerial work that you can't do during passenger transport. So your single manual will need to obviously identify activity-based things for your pilots, but broadly, one application, one set of manuals, unfortunately multiple pieces of paper. So we're a small operation. Will the burden effectively require a full-time person in order to comply with CASA's requirements?
So I'm just going to take a guess here, and I'm assuming you're talking about the safety manager potentially as the full-time person. So the Part 119 guidance material very clearly lays out that a safety manager does not have to be a full-time person. In fact, from CASA's expectation is for many smaller operators that it definitely won't be a full-time person. The potential exists for a company, for example, to provide contractor staff that may be the safety manager for multiple operators. The potential exists for one of your pilots, if they have the appropriate experience, to be a part-time pilot and a part-time safety manager. The only people that can't double up effectively is the CEO and the safety manager. The reason for that is because in order to effectively run a safety management system, there needs to be a level of independence from the safety manager and the CEO. So, but for smaller operators, for example, the CEO could be the head of flying operations, and they could also be the head of training and checking, and then you could just have a part-time safety manager that runs your safety management system.
And certainly within the maintenance regulations, there's some very small organisations that have managed to comply with Part 42, including the requirement for safety management systems, following the CASA safety management system kit. Yep. So follow the bouncing ball in the kit and generate a manual with quite a small organisation.
Yeah.
Okay, how do the checking and training requirements for Part 135 relate to the ones in Part 61?
Yeah, so thanks for the question. So Part 135, training and checking, probably the critical way to understand is that the training and checking requirements in 119 and 135 are the operator's training and checking requirements. So they're the ways that you assure yourself of the competency and the continued competency of your crews. So, for example, there is the potential for significant overlap between Parts 61 and 135. For example, if an operator had a reasonably simple and non-complex operation, the operator may choose, for the sake of efficiency, to have their operator proficiency checks also double up as instrument proficiency checks, for example. They could also double up as a flight review. So if you're going to have your operator proficiency checks double up for those Part 61 requirements, then you would need to have the person conducting the review or the check meet the Part 61 requirements. For example, be a holder of a flight examiner rating. But obviously, as you would be aware, there is provisions in Part 61 for a training and checking system to substitute for some of those requirements in toto, and there is the ability for certain nominated members of the operator's personnel to be nominated as, check or training pilots in a similar fashion to what is currently done for CAR 217.
Yeah, so you'll be able to do your Part 61 and your Part 135 requirements at the same time if you chose, and there's a requirement for the people conducting the training and checking if you do that, or you could do them separately. So if you look at some of our large airlines at the moment, they have a recurrent training and checking system that meets all of their training and checking requirements, but doesn't give IPCs for their crew to go off and do private flying, for example. So how you choose to implement that Part 61 and 135 requirements is really up to the organisation and what you need to achieve. So there's a question about does the proposed Part 135 represent best practice regarding scenic flights and joy flights. In the US, for example, are scenics and joy flights considered transport, and if not, why are we doing it here? Will 138 allow scenics and joy flights?
So at the moment, again, thank you for the question. So scenic flights and joy flights, as CASA wrote in the summary proposed change document that accompanies this consultation, we have previously consulted on this topic. The current version of Part 119 doesn't contemplate any changes to the current state for scenic flights and joy flights. Currently, scenics and joy flights are treated as charter flights. So under the current version of Part 119, they would therefore be treated as air transport flights. However, as the summary proposed change document states, CASA fully intends to consult this issue separately with industry in 2019. So certainly the US has a number of different ways that scenic flights and joy flights can be conducted. They can be conducted as a Part 135 operator. There is obviously a particular Part 91 rule that applies to scenic flights and joy flights that brings in some other aspects of rules such as drug and alcohol, the carriage of additional equipment in exchange for certain conditions on that scenic flight. Again, these are the types of matters that CASA will be looking to consult with industry on in 2019.
So what you're proposing is that at the moment we make the rules as they stand, which would have scenic flights in 119 and 135, but we're open to suggestions and we'll consult in more detail next year and potentially modify the rules before they commence.
Absolutely. So again, this is one of the reasons why we deliberately gave ourselves time between the making of the rules at the end of this year and the commencement of the rules in early 2021. I really do want to emphasise that we fully intend to consult with industry in relation to scenic flights and joy flights in 2019. And once the outcome of that consultation is determined, then we would change any relevant rules that need to be changed well in advance of the commencement date of March 2021.
Great. Will we be able to operate our Cessna Caravan in Part 135, or will we be forced into Part 121?
So the answer to that is it depends on how many people you wish to carry in your aircraft. So there is the dividing line between Parts 121 and Part 135 is based both on weight, which doesn't really apply to the Cessna Caravan, but it's also based on this concept of MOPSC, or, as I said before, maximum operational passenger seating capacity. So if you wish to operate your Cessna Caravan with an MOPSC of 9 seats or less, then you would be wholly and solely within Part 135. If you wish to operate it with more than 9 passenger seats, then you do fall into Part 121. However, this was a topic that has been discussed with industry over many years. The result of that has been that there's a special section of Part 121 called Part 121Z to which a single engine aircraft that is both less than 8,618 kilos, which is obviously the Caravan, and more than 9 passenger seats. And the rest of Part 121 doesn't apply. So Part 121Z is the only part of Part 121 that applies to the Caravan when you choose to operate that aircraft with the ability to carry more than 9 passengers. And there's just a couple of additional rules over and above the rules in Part 135 that will apply to you.
Okay, great. Will the aerodrome requirements in Part 135 eliminate a lot of the traditional landing places for charter aircraft?
No, certainly not. So our intent in writing the aerodrome rule requirements in Part 135 was largely to carry over very similar requirements to what's currently in CAR 92. So there's a general requirement that the operator determine that the aerodrome or the place that you're planning on taking off and landing is a suitable place for taking off and landing. We've then outlined in the regulations a number of matters about which you need to satisfy yourself. In essence, what we're asking is, before you go and land somewhere, establish the characteristics of the place that you're taking off and landing from, and also, if necessary, establish any special procedures for engine failure, for example, that your crews will need to follow at that particular place of landing or takeoff, such that you can ensure as an operator that you're going to conduct safe operations.
Okay. This is similar to the question that was asked before, but see if there's anything different in how we need to address it.
Sure.
Could Australia adopt something similar to FAR Part 91.147, National Air Tour Safety Standards for scenic flights that operate up to 25 miles and with no outlandings? These flights could operate in a 141 or 142 environment without the need for Part 135 and the added complexities.
Yeah, so again, I just want to emphasise that, that possibility definitely exists. Other possibilities also exist. These are all matters that we fully commit to consulting with industry, through the Aviation Safety Advisory Panel, technical working group process, and through a public consultation process, next year in 2019. Yeah.
Okay. Under the new regulations, will Part 135 have a similar provision for air taxi services like the US FAA's Part 135 does? Will it be possible to sell individual seats on non-RPT charter flights, i.e. excess seating capacity on pre-booked charter flights, to maximise revenues and operational efficiency? Also, can empty leg flight sectors be sold on specific dates on a per-seat basis?
Okay, yeah, once again, thank you for the question. So from a aviation safety regulatory sense, CASA hasn't put in place any rules surrounding those matters. So it's entirely a matter for the operator whether or not they sell seats on that basis. There may be other factors that apply to you. For example, if you have a contract to provide, if a company has chartered your aeroplane, then obviously it would be a matter between you and the company that's chartered the aeroplane whether or not that company is happy for you to on-sell, if you will, the 3 spare seats or the 2 spare seats on that aeroplane. From an aviation safety perspective, CASA's only interest is in making sure that you comply with the regulations, and there are no regulations relating to how you can or cannot on-sell seats.
So at the moment, there's obviously differences between charter and RPT, and the question is very relevant under the current CAOs, but that difference effectively disappears once we bring in the new rules, and existing charter operators will be able to carry passengers on their mail runs or advertise scheduled flights as RPT do today.
Yep, absolutely.
Are there any changes to performance requirements in the new rules?
So, in essence, in combining charter and RPT, what we've done is we've looked at the existing rules for performance. So, in large part, in the less than 5,700 kilo space, the rules in Part 135 essentially are the same as CAO 20.7.4, and the rules in the greater than 5,700 kilo space are essentially the same as CAO 20.7.1b. However, the wording isn't exactly the same. We've taken the opportunity to modernise and contemporise the wording of those rules. Obviously, they are quite old and they haven't been updated for some time, but that's the generics of it.
Okay. No worries. What's the plan for maintenance rules or continuing airworthiness for Part 135?
Yeah, so basically CASA has obviously recently announced, and I think there's actually out for consultation at the moment, there's a discussion paper on general aviation maintenance. It's important just to note that from a CASA definitional perspective, when we talk about general aviation, we're not talking about the charter space currently. General aviation rules in relation to maintenance that we're talking about are, in the future, they would be aircraft that are operating solely under Part 91, aircraft that are operating under flying training, Part 141, 142, and aerial work aircraft, Part 138. So following on from the GA maintenance project, which is currently the subject of initial consultation, CASA plans in 2019 to follow on and have a further public consultation process surrounding the rules for charter maintenance.
So basically at the moment the rules are unchanged in that space.
Yep.
So what the maintenance rules that apply to you today will effectively apply to you come transition to these rules in March 2021. Between now and then we'll have reviewed the rules for air transport, continuing airworthiness, and introduce them with an appropriate transition period. So they may not commence at the same time as the operations rules, but we'll certainly know exactly what the rules are well in advance of commencement of the operation rules.
Absolutely.
So what's the weather radar requirement, and is this different from now?
So, yeah, I mean, the weather radar requirement is almost identical. So in essence, the only extension we've done to the weather radar requirement is if you're doing night VFR operations in addition to IFR operations, then you need to have weather radar. But that's obviously not for everyone. It's for the same type of aircraft that are currently required to carry weather radar. It's just that if you're doing night VFR ops in those aircraft, you also need it.
Okay, great. Will Schedule 5 and pilot maintenance be allowed under Part 135, or will it all be MM, maintenance manual, I assume?
Yeah,
I guess you probably covered that by the last question.
Yeah, I think so. But certainly, again, I just want to emphasise that CASA we very much understand that obviously the future maintenance rules are a matter of significant interest to industry. And again, we fully commit that in 2019 our plan is to discuss this matter with industry further. Yeah.
No worries. When do we need to redo our expositions and manuals, and when does surveillance start? I'm happy to take that one.
Sure.
As I mentioned in the timings, we basically plan to have all of CASA's material ready by, say, March 2020 to give a year for industry to comply with the new rules. What we're looking at is prior to March 2021 for industry, the onus to be on industry to update your manuals, but not to have a full CASA assessment process like we've had with Part 141, 142. So you'll need to comply with the new rules on the first day of operation of the new rules, so that March 2021 kind of time frame, but don't expect to go through a Part 141, Part 142 style full-blown assessment with CASA to get there. We're basically going to continue your existing AOC on the assumption that you've complied with the new rules, and we'll start surveilling against those rules in the March of 2021 kind of time frame. And, obviously if we find things wrong on day one, we're not about to cease operations unless there's something drastic going on. Really it'll be, providing advice and getting you across the line. I anticipate, even prior to the commencement of the new rules, that during our surveillance activities we'll take the opportunity to talk to you about what are the differences between what you're doing today and what you'll need to do in the future, having a look at your gap analysis and your transition statement, and basically saying, okay, well, just remember we need to do this by March of next year, or for things with delayed provision by whichever later date we get to at the end of this consultation.
Yep. I'll just follow on from that very briefly, just in relation to your manual set. So again, our intention is to make the maximum use of deeming provisions such that we would deem your existing manual set, in relation to the content that is, if you will, continuing across the rule changeover to be equivalent to an exposition. So you don't need to replace your manual set with an exposition on the commencement date in roughly March 2021. Your existing set of manuals will be deemed to be equivalent to an exposition. However, you will have to update those manuals to take account of the new rules.
So it looks like we've only got one question left at the moment. So if there's something that you're wondering, please don't be shy. We'll be wrapping up shortly. So the TORS requirement, can you explain what the TORS requirement is in a bit more detail? Yeah,
certainly. So the TORS requirement as it currently sits is only for aircraft greater than 5,700 kilos. So if you're a turbine-powered aircraft greater than 5,700 kilos, the requirement is TORS A. And if you're a piston-powered aircraft greater than 5,700 kilos, the requirement is TORS B. That matches the ICAO requirement, the European requirement, for example. We did initially look at utilising the FAA requirement. The FAA Part 135 requirement is for all aircraft that can carry more than 5 passengers, so 6 passengers and upwards, are required to be fitted with TORS B. But after discussion with our industry working group back in June, we changed that requirement from a passenger seat-based requirement to a weight-based requirement.
Okay. Yeah. Another example of trying to take feedback from industry and incorporate it into the rules.
Yeah.
Fantastic. All right, so look, the flight operations regs, including parts 119 and 135, are intended to reduce the safety differences between charter and RPT. We're looking to bring all of the rules into one place instead of scattering our rules throughout the CARs and CAOs. There's a fair bit of additional operational flexibility provided by the new rules, and we're looking to incorporate international best practice and, where appropriate, ICAO standards and recommended practices. As we've discussed a little bit tonight, we have previously consulted on the rules, and we've also incorporated recent industry feedback into the consultation draft that's available for you today. Look, at the end of the day, whilst we're changing the rules and there might be some additional requirements written down under law, most of you are already achieving the intent of the new rules. You know, they represent good business practice, or in a lot of cases, your customers already require you to do BARS audits or IOSA audits, or have some sort of quality system or a safety management system that's not a CASA-imposed requirement. So this really reflects good business practice and things that you're already doing today. We're also looking to learn from recent regulatory transitions that we've done. Parts 42, 145 and 141 and 142. And so we're looking to learn from those experiences and make transitions simpler for both industry and CASA. And thus we're going to have, you know, a longer period prior to commencement and no transition period for these rules, with the idea of getting CASA ready and giving a period for industry to then use CASA sample materials to easily transition on a single date. It's important also to look at CASA as a regulator. Who are we working for? And I guess, you know, one of the things that we're really looking to do with the new rules is provide confidence to the travelling public that your business is a safe way to get to where they want to go, whether that's a scheduled service or a non-scheduled service. So clearly the small aeroplane sector is important to Australia. You know, this consultation is all about seeking your input to ensure that we haven't put some unintended consequences in the new rules. So from here, you know, please jump onto the consultation hub on the CASA website and provide us your feedback. You know, there's separate areas for feedback on 119 and 135. There's a lot of supporting material there. Also, you know, we think these webinars are a good way of engaging with industry. You know, alternately, we've sort of travelled around the country and we can't really get to everyone. This allows us to get to people, you know, in capital cities and regional areas. So if you want to give us some feedback on the webinar format, please do that as well. The consultation closes on the 2nd of September, and I guess I'd just like to, in concluding, thank you for joining us for the presentation tonight. I really hope you got something out of it, and we do look forward to your feedback. Thanks very much.
Yep, cheers. Thank you very much.